The claim. After passing through the House of Representatives with the support of Labour, the coalition's Religious Discrimination Bill, a 2019 election commitment, has been indefinitely shelved, thwarting plans from the opposition and crossbench to amend the legislation in the Senate. Labour's support for the contentious bill came under scrutiny on a recent episode of the ABC's Q+A, when a questioner asked Shadow Minister for Education and Women, Tanya Plibersek, how she and her party could support the legislation. Loading. In response, Ms. Plibersek noted that in lots of parts of Australia, people of faith don't have any protection at all. Right now in Sydney, if you're a Muslim woman sitting on a train and someone yells at you for wearing a hijab, you've got no protection under the law from that, she said. Is that correct? RMIT ABC Fact Check investigates. The verdict. Ms. Plibersek's claim is overreach. There are no religious vilification laws at either state or federal level which would protect someone in NSW from vilification, as described by Ms. Plibersek. But experts told Fact Check other legislation could come into play. For example, laws governing offensive language in public and behavior on public transport could offer the woman some protection against the harassment described. As one expert said, there was nothing to stop the use of offensive language laws to address public Islamophobic comments. There are laws which offer some protection from religious vilification on public transport. The context of the claim. Ms. Plibersek's claim was made in the hours following a decision by the government to indefinitely shelve its Religious Discrimination Bill, a 2019 election promise. According to the text of the proposed legislation, its objectives are to recognize the freedom of all people to have or adopt a religion or belief of their choice, as well as the freedom to manifest this religion or belief either individually or in community with others. Specifically, the bill aims to eliminate discrimination on the grounds of religious belief or practice, and to ensure all people have the same rights to equality regardless of religious belief. Controversially, the bill also contains a clause ensuring that people are free to make statements of belief, which, as the Shadow Attorney General, Mark Dreyfus, argued in Parliament, would override any existing anti-discrimination laws. Lawyers can argue about the precise legal impact of this provision, but it is impossible to escape the fact that the provision is drafted in a way that suggests people of faith should be able to discriminate against other Australians on the basis of race, gender, sexual orientation, age and disability, Mr. Dreyfus said during debate about the bill in the lower house. This is what the provision says. It literally says that a statement of belief will not constitute discrimination under any of Australia's existing anti-discrimination laws. It is this provision that the questioner on Q+ referenced when asking Ms. Plibersek about her party's support for the legislation. People of faith already have some of the strongest protections in this country, the woman said. What this bill will do is allow discrimination in the name of faith, not only towards LGBTIQ+ folk, but also women, unmarried parents, people living with a disability, people from multicultural backgrounds, and people of other faiths. Ms. Plibersek's response to the questioner did not touch on the statements of belief clause, but rather focused on Labor's support for a religious vilification amendment to the bill. We, Labor, do think that people of faith need to have protection from discrimination and vilification, just as every Australian deserves to be protected, she said. What happened with the bill? In the early hours of February 10th, the day Ms. Plibersek appeared on Q+A, the Religious Discrimination Bill passed through the House of Representatives with the support of the Coalition and Labour. M to mute, left and right arrows to seek, up and down arrows for volume. Watch 2 minutes 43 seconds 2 minutes and 43 seconds Federal Government shelves Religious Freedom Bill indefinitely. A crossbench amendment to the Sex Discrimination Act, designed to protect transgender students, also made it through the lower house after 5 Liberal Party MPs crossed the floor to vote against the government. Other amendments, including a Labor proposal to include a religious vilification clause in the religious discrimination legislation, as well as one addressing the statements of belief clause, failed to find support in the lower house. Labor's religious discrimination amendment would make it unlawful for a person to engage in conduct on the ground of religious belief or activity of another person or group that would be considered to threaten, intimidate, harass or vilify that person or group. According to Mr. Dreyfus, meanwhile, the Statement of Belief Amendment would ensure that no existing protection against discrimination would be impacted in any way by the Statement of Belief Clause. Despite failing to pass these amendments in the House of Representatives, Labor reportedly planned to fight for them in the Senate, where the government does not hold a majority. However, when the bill reached the Senate later on February 10th, a motion to ensure it would be debated that day was voted down and the bill was automatically adjourned to the next sitting, the Clerk of the Senate, Richard Pye, explained. As to what happens next, the bills are on the Senate's notice paper, Mr. Pye said in an email. The government is given the power under the Senate standing orders to list bills in its preferred order, so it is a matter for the government whether and where to list the bills for debate. As previously mentioned, the government has indicated it does not plan to bring the bill on for debate before the impending federal election. Anti-discrimination laws in NSW. Discrimination law in Australia exists at both a federal and state level, as Fact Check has detailed in a number of previous articles. Simon Rice, a professor of law at the University of Sydney, told Fact Check that neither any federal anti-discrimination law nor the NSW Anti-Discrimination Act prohibits religious vilification or religious discrimination. The woman in the example cannot complain that the religious vilification or religious discrimination she suffered was against federal or state anti-discrimination law, he said. In New South Wales, the state in which Ms. Plibersek's example takes place, the Anti-Discrimination Act 1977 offers protection from vilification on the grounds of race, gender, sexuality, and HIV/AIDS status, but does not extend to religion. A 2021 attempt to amend that bill to cover religious discrimination, introduced to the NSW Parliament by Labor MP Paul Lynch, failed in the lower house after not receiving the support of the governing Liberal Party. Notably, however, the definition of race within the Anti-Discrimination Act includes ethno-religious status, as Luke McNamara, a professor of law at the University of New South Wales, told Fact Check. He explained that courts had held that Sikhs and Jews were covered by that definition, but not Muslims. Additionally, in a 2014 case against radio host Alan Jones, the NSW Civil and Administrative Tribunal ruled only that comments made about Lebanese Muslims, and not Muslims in general, were classified as racial vilification under the Act. The relevant Commonwealth legislation, the Federal Racial Discrimination Act 1975, also fails to specifically outlaw vilification on the grounds of religion, though Section 18C does offer protection from offensive behavior because of race, color or national or ethnic origin. Similar to the NSW anti-discrimination legislation, court rulings have found Section 18C to cover offensive behavior directed towards the Jewish community. In a 2016 article for the UNSW Law Journal, Professor McNamara and co-author Catherine Gelber wrote that it was surprising that no authoritative ruling had been made on whether Section 18C applied to Muslims as a group. The likely answer, based on the jurisprudence associated with the terms race and ethno-religious in other jurisdictions, is that it does not cover conduct that vilifies Muslims unless the conduct also vilifies a person defined by race, color or national or ethnic origin, the pair said. Professor Rice also referred to such case law at both the federal and state levels, telling Fact Check court decisions had decided that being Muslim is not a being of a race, so the legislation offers no protection. Offensive language laws. While state and federal anti-discrimination legislation may not offer protection to the woman in Ms. Plibersek's example, the experts suggested that other laws could apply. It's probably not what Ms. Plibersek was getting at, but, depending on exactly what was said, the NSW Summary Offences Act does prohibit offensive language in a public place, Professor Rice noted. Under Section 4A of that Act, a person must not use offensive language in or near, or within hearing from, a public place or a school. According to a different journal article authored by Professor McNamara and Julia Quilter, a professor of law at the University of Wollongong. It was